Eddie Gardner Jr.
People. Your Honor, great to see you. Christina Constantino, hearing on behalf of Mr. Eddie Gardner.
Good to see you.
Thank you. Could you please state your name for the record?
Eddie Gardner. All right. As to, I guess, the first order of business is there is now a count 3. Counsel, were you aware of that?
Judge, I was made aware of that late yesterday.
All right. As to the arraignment on that charge?
He wishes to stand mute and waive a formal reading.
All right. Defendant having waived formal reading, court will enter a not guilty plea as to the added count 3. And you're requesting an adjournment of this?
Yes, Judge. Given that there are new charges added here, I need additional time to discuss that with my client.
All right. Probable cause conference without objection, May 1st, 2025, 9 a.m.
I'm really sorry. I'm in trial that day.
So, no.
You did the Thursday before?
Yeah, I think I can squeeze it in that date. That's not a problem. So the 24th. April 24th, 2025, 9 a.m. Bond continued.
Thank you very much.
Thank you. She knew she'd do that. That's no, you're not. Court calls case People versus Miguel Aprecio Navas.
And is that on behalf of you, Your Honor?
Court calls case of the People versus Zachary Bruno.
Assistant Public Defender Hannah Apple here on behalf of District Bruno. Continue for the record, sir.
Zachary Bruno.
With some outstanding discovery that we still need, I'd be asking for adjournment.
Hearing no objection, probable cause conference will be adjourned to April 24th. 2025, 9 a.m. Bond will continue.
Thank you.
Thank you. Court does call the case. People versus Kane Kellenberger.
Mr. Kellenberger, Your Honor.
Your name, sir?
Kane Kellenberger.
Thank you. You're requesting an adjournment.
Yes, please, Your Honor.
24th work.
First, we do May. The 24th is fine.
You want May 1?
May 1st would be partially better. Thank you.
That objection, May 1st, 2025, 9 a.m. I don't know why I'm being nice today. What did you say?
Practice on leaving after this one.
Yeah, are you? Well, good.
I'll look for our twos over.
All right. Thank you. Court calls the case People versus Lawrence Buckner.
That's one people.
Assistant Public Defender on behalf of Mr. Buckner.
Your name, sir? All right.
Your Honor, so obviously we're here for a probable cause conference. I have a chance to speak to prosecutor Buckner. I think we'd like to set this matter for further examination.
All right.
There's currently 2 steps for April 20th for the accommodate that date.
April 20th,
22nd.
22nd. Who are those before?
Just one.
Okay, the 22nd is the date I'd give in any event. Those are set already before.
Yeah,
Okay.
There's one. I don't want it. It's fine. The other one is Mr. Johnson's case.
They are.
I believe it's all the boxes.
They're both set. With Washington. All right. People don't have any objection to that.
No, we'll try for that date, Your Honor.
All right. Preliminary examination in person, April 22nd, 2025, 9 a.m. before Judge Washington. You may.
Yeah, Mr. Buckner's here. He's not a flight risk in any way. Locally, I believe that the objectives of the court could be accomplished in terms of any violation or any kind of contact with any of the witnesses in these matters. Could be achieved through a tether or a hot zone or a heat zone. As I said, he's not a flight risk. He has a bond. I believe the bond in this matter is $75,000. In looking at it, I think there's a bond of remand in the MDOP case, which is not case I'm representing him on. But I'm not quite sure if that was
It's two other cases. What do you have as this one? Because I don't have those before me, so.
if I don't. I need to address the bond
Well,
in the case.
Mr. Buckner was gonna try to say something, but I don't know if you want him to say anything, Mr. Biddy.
Judge Simpson, last time I was in court, I came here to go to court. Prosecution had brought up intimidated witness charge. You said that you were going to remand me back to Washington County Jail until you get that video to see if I actually threatened the witness.
Well, until, right, but let me just clarify that. I was gonna look at it as to whether or not I was gonna do a remand prior to the charges coming forward. The problem was the charges then came forward. And so I arraigned you on the charges. So there was a distinction in what I was doing at that point, but go ahead.
I was under the impression that once you look at the video and see that any criminal activity was done on my part, that you would reinstate my bond. In my words, watch the videos. I didn't do anything. It's he say, she say. I wasn't on the video for any crime, sir.
Okay, so Mr. Buckner, just so you understand what I was doing. Remember at the time that you appeared here, and a flight risk is not my issue with Mr. Buckner at all, because he voluntarily came in and he cooperated with the court in every respect whatsoever. But at the point at which we were addressing it and it was brought up to the court, I did not have a complaint in the case. And so what I was doing, the people at that point were asking to have you remanded, defense counsel, and you were objecting to that. And at that point, I was going to make a decision as to whether or not I was going to remand with knowing that the charges may be coming. But I wanted to look at something because you were vehement in saying no, people, and I knew that there was this video there. Before I could even get to that, the charges came through. And so then at that point, you were arraigned on the charges themselves. So there was at least some determination, although minimal, that the actions occurred because the charges had come forward. Okay.
Judge Simpson, I would like to say in closing, I appreciate you. However, I was brought back up to see that one had informed me that you didn't get to watch the video, but you did.
I know. Okay, so we can go, Mr. Ruckner, we can go through all of this. The problem is it doesn't matter what the bond in this case is because he's denied on his other case. So I'm not going to change everything, let it all get before Judge Washington. She can make a determination of your bond. She can hear this argument of the bond in this case, as well as what's going to have to be your argument in the other case. Because I could change your bond in this one, it doesn't release you.
I'm talking about the $75,000 bond. I'm talking about the bond. I came to court for I was at the court for the day of the gun charge, no, the MDOP case. They told me, you know, it is what it is. Yahweh, God of the universe will vindicate me, and I'm thankful for all this time. Thank you for the time.
All right.
You know, we get to 2 weeks in jail, time to sit there. No weapon formed against you shall prosper. and he lies, I will be vindicated. I will be vindicated. And I hope, and I will be filing initial prosecution against Washington County for everything that they did to me since my shooting.
All right. So what I'm gonna do is I'm gonna deny, just so that we have a record of it, I'm gonna deny your request. The reason I'm denying it is because he's held on the other matter. And then this exam will be set on the 22nd with all his other matters before Judge Washington. Bond will continue. In this.
Thank you, Your Honor.
Thank you. Hey, Mr. Gardner, that's where the problem comes in. Just walk out quietly or go out quietly, please. I've been that for 60 some odd years. I get it. I don't know. I was just focusing on the whole hard to be or whatever. And I was gonna ask Feaster and Lauren for their opinion. Oh, okay, all right. I'm just asking. All right, I didn't know. Court calls the case, People versus Matthew Fitzgerald.
Good morning, Your Honor. Wonderful to see you as always. Robert Allen on behalf of Mr. Fitzgerald on the case ending 5072.
You started out so nice because he's not here.
I'm just gonna get nicer as we go.
Your Honor, good morning, Your Honor. It's so nice to see you. Your Honor, on behalf of Mr. Fitzgerald on the case ending 5073.
And Your Honor, if I may, if one correctly noted, Mr. Fitzgerald is not here. I was informed that he called the court this morning and said that he went to 15th District Court on accident. I know that was some time ago, however, it snowed. And with the snow on the roads, who knows how long it takes to get here. Abrupt change in weather.
The roads were clear.
It's Michigan weather, Your Honor.
Did we get a phone list? At 9:07 to say he was at 15.
Might be on slip there. He also is a lot of construction.
There is construction as well. It's a mixture of the seasons.
He also filed a request to appear remotely, but he has a bond violation, so it was denied.
Got it.
This also came after he went to 15.
This
Came this morning after.
came after, but was denied because he has his bond violation. Well, so he went to 15. He's heading here.
That is my understanding of the information in the leak.
Okay. You're aware of his bond violation?
I was made aware this morning, Your Honor.
Okay, then I'm gonna do you a solid. I'm gonna pass it. And I can't wait.
I thought it would be nicer.
Thank you, Mr. Bellman.
Thank you, Your Honor.
Court calls the case, People versus Kyle Burmeister.
This is a public defender, Dave Allen, on behalf of Mr. Burmeister, who is approaching. Maybe just say that Thursdays are my absolute favorite day.
Wow. Gee, mine too.
Your Honor, we're here on a PCC today, as this court knows. I am just requesting an adjournment to the 24th. I would respond, we're going to hear it. I understand that he has a remand on his other matter that's up on the 24th. I understand, of course, not willing to hear that today. However, my client has some concerns in that he does financially support himself. He works at a couple of different places. If he's potentially going to lose his job, he'll lose his apartment. He is in outpatient treatment at IHA Addiction Recovery at St. Joe. He's willing to comply with the GPS tether testing requirements. He's already got a release of information signed out of St. Joe where he does testing. Like I said, I know that he's remanded on his other matter, but if the court is willing to potentially give him a PR on both matters, or okay, I will prepare a bond motion for the 24th, and I understand
That's
Okay.
his next BCC to do, so.
All right. I'll adjourn this to then April 24th, 2025, 9 a.m. Bond in this matter will continue.
Thank you.
Thank you. Court calls case People versus Julian Ward. Oh, I thought she left. No, I'm kidding. I didn't mean it that
Still
way. All right.
Christina Costantino appearing on behalf of Mr. Word. Mr. Word, can you please state your name for the record?
Thank you.
Judge, this is the date and time set for PCC. At this time, we would be asking for an adjournment of this matter so that we can have some additional time to review the discovery.
All right. And the first doesn't work for you, so you need the 24th.
Yes, Judge.
24.
That would be great.
April 24th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
Thank you.
Have a great rest of the day.
You do
I'll
the
see you
same.
this afternoon. I'll be back.
Why? I mean, no, no. Oh, I'll look forward to it. That's what I meant to say. Sometimes I say things wrong. Court calls the case People versus Mark Capaldi.
Absolutely. People. Officer Bashir, Lincoln on behalf of Mark Capaldi. Mr. Capaldi seeks to hold his preliminary exam on this matter at the earliest possible date. This, to our knowledge, discoveries.
All right. Your name, sir. Thank you. People have their witnesses available on the 22nd.
Well, Your Honor, for the record, this defendant appears in custody, but he is not in custody on this matter.
Oh, he's in custody on something. Got it. All right. Yes, I do see he posted on this one. All right. Preliminary examination in person, April 22nd, 2025, 9 a.m. That will be before Judge Fresh Hour.
Thank you.
Bond will continue. Thank you. Court calls case People versus Beverly Boss.
Good morning, Your Honor. Law.
Thank you. All right, what are we doing?
Your Honor, we are setting both matters for hearing section.
All right, discovery is complete in both cases. All right. And would the people have their witnesses available the 22nd?
Your Honor, we will certainly try our best, and I gave an address on for you.
Pardon?
We will try our best, and I wanted to address bond, please.
All right. Go ahead before I set the date.
Thank you. So the last time we were here, I had inquired about whether or not there was testimony in the box spaces, and I think we spent so much time trying to figure that out. I was not able to actually articulate the request that I wanted to make. The court did not receive complete information, so I wanted to, if I could, renew or make that request and fill in some of those blanks.
Go ahead.
We just think that the scratch tether at issue in one of these cases was cut off or allegedly cut off while Ms. Boss was on probation for 4 separate OWI cases in the circuit court. She had been almost completely non-compliant while on bond and probation with testing and treatment. The reason that no testing appeared to be ordered on these cases is because she was already under an order at the time, given that that stern order was in effect. However, her probation was revoked for all 4 of those felony OWI cases. She was sentenced to serve the remainder of the jail term. And there was a competency evaluation in the middle of all of that, with a finding of competency around the same time she was scheduled to be released from jail anyway. Given that, I'm very concerned. Ms. Boss has a severe drug and alcohol abuse history that is very long-standing. I don't actually see a history of compliance at all in any way, whether it's bond or probation terms. I did let counsel know I was going to be not only bringing this up, that I would not be considering any sort of offer until I'm able to monitor for compliance. With that being the case, that is why I'm requesting that Ms. Boss be placed on another scram tether. There is also a narcotic use history as well. If the court sees fit to order that, I'd appreciate it, but at the very least, I would ask that we can please get the scram tether back on Ms. Boss.
Response.
Yes, Your Honor. I did 365 days, and I was, I have a domestic violence advocate through Safe House and was raped in my telegram. I called the cops several times, and there's police reports on it. that they tried to chase me down. Okay. And on my drunken driving, I did my crime, did my time, and paid all my. And I do have mental health and substance abuse, Your Honor, and I do go to counseling.
I did discuss,
So what do you want to add, Kessel? No.
Sorry, Your Honor.
we talked about the potential for going down for testing, and you said you're okay with that. We're not gonna have objection.
For sex trafficking, sir, I'll do if you can do a breathalyzer, the sex trafficking, people will put you on vehicles and cut it off and make fun of you and chase you down the road.
I got you. Okay. What I'm gonna order is weekly ETG testing at community corrections. So ma'am, you'll have to get to community corrections for the testing. Okay? I'll order that at this time, so if we can prepare that order. All right. Then I will set her preliminary examination. Everybody will be ready to go on the 22nd. Preliminary examination, April 22nd, 2025, 9 a.m. That's before judge. Fresh hour on both matters. The bond with that one modification will continue. Got it.
Yeah. Thank you.
Thank you. Court calls case People versus Gregory Davis.
Good morning, Your Honor. Lord Mackey, Assistant Public Defender with and on behalf of Mr. Davis, who is printing and now standing to my right. Mr. Davis, can you say your name for the court?
He has another case coming down.
That's my understanding, Your Honor. That is why we adjourned it last time. I put in my green sheet reluctantly, because obviously Mr.
Well, where's the case? Does he have another case?
I'm happy to fill in those connected to it.
Well, go ahead.
Mr. Davis had two other cases pending at the last, essentially at the last hearing. He had a case scheduled for preliminary exam. That case ended up being dismissed because the OIC is unavailable for several more months and we can't proceed without that individual. And then there was a warrant pending that I needed to review so that we would have all of Mr. Davis's cases ready to deal with at the same time. I did communicate to Ms. Young last evening that unfortunately
Bless you.
I'll have to further that case. I respect the response very promptly. There's just a piece of missing information in that file before I can complete authorizing those charges. But I do anticipate probably unlawful driving away with automobile charges coming.
What do you want to do, Michelle?
I think it would make sense to have, if there is another case coming, to have them consolidated. And normally I would make a bond argument in this situation. And this case just keeps getting more confusing because Axial says this is the only case holding Mr. Davis. But when I looked on JIS, I saw that there's a 14B case that he may or may not have been arraigned on yet, that may also be holding him. He's set for court in 2 weeks or on Friday, April 25th. Is his next court date in that case. So my belief is that that case, even if he was to be released on this case, he would not be released on that case. Even though
Is that the case? Is that holding you? The 14? Can we look and see if we see anything at 14B?
I see it's a domestic violence case that's a township matter, that there's getting warrant set.
That's the one that I'm at. Yeah.
Actually, I don't know.
Got it. So he hasn't been arraigned on that. Okay, got it.
It appears that he was arraigned on 2/24 of 25 and he received a $15,000 cash and surety bond. But I'm not really sure what happened afterward. It was removed from, oh, I see. He had a bond violation, so there's no bond on that matter due to potentially the violations with these other matters.
So probable cause April 24th, 2025, 9 a.m. All right. And then I'll have his bond continue in this case since he's got that denied in the other. And he won't, the problem is, if I set it for the 24th, so that you know, his other case that bond denied won't be addressed until the 25th. So if what you want me to do so that we're clear, I'm just trying to get him before this court as quick as I can set this for the 1st of May. That way, when we come back, we know what happened at 14B, because that's really what's potentially holding you. And we know maybe about these other charges.
No. So, Mr. Davis, what I think makes sense, but it's your decision because it's your cases. I think it makes sense to come back the 24th, even though we don't know what's happening with your 14-day case. I think it still makes sense to come back on the 24th for this. But if you'd rather, what the judge is saying is if you'd rather give an extra week, so you know what's happening with your other case before you come back for this case, he's willing to do that.
I'm just trying to save my job. I got too much.
No, I know. I'm just trying to get you here as quickly as possible.
Yes.
But if that did not, I want you to understand that if on the 24th, when you come back on this case,
Yes.
that 14B matter will not be resolved. So you won't be getting out on that date either.
Okay, yeah, that's gonna be that case like come to a close because I was out of town.
Well,
So,
okay, all right. We'll do the 24th.
All right, thank you.
I'm gonna stop being nice. Miss Zenda was telling me that. She told me I was being too nice. She was scolding me. Court calls the case, People versus George Bowman.
Action on the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Bowman, Your Honor. I have had a chance to speak with Mr. Bowman. Mr. Bowman, state your name.
George Bowman.
Thank you.
Your Honor, I'm asking the court to adjourn this matter briefly. I'm going to try and get them assessed for a judgment. Right. Or I do have to.
All right.
Not opposed to court, Your Honor, may we heard our bond.
Yes, I'll adjourn this to May 1st, 2025, 9 a.m. Esteban.
This is a true report of the UI, and I reviewed the community charge report that does indicate a defendant to be compliant. However, it also indicates billing testing twice a day, the request that he be testing 3 times a day.
He's got a sober line.
Yes, Your Honor.
All right.
Your Honor, I did receive a bond update yesterday. He is completely compliant. He is tested every time required.
So that you make that up on your own? You make that up on your own? Here's what I'm saying.
Oh.
Okay. What I'm gonna do, my standard on testing on the SoberLink is 3 times per day. So I'm gonna increase its testing to 3 times per day. And if you want me to look at that on the May 1st, then fine, I'll take a look at that on May 1st, but I'm gonna sign an order so that sir, you've been testing 2 times a day on your SoberLink. That's gonna go up to 3 times a day, so there'll be a test in the middle that you'll have to comply with. I'd suggest that you stop over at community corrections just to get the time frame so you don't miss your blow, okay? And so I'll sign that order when I get it, and then bond will be continued. Thank you.
Thank you, sir. I'll have another folksy expression.
I'm sure you will. Court calls the case, People versus Adam Lee Harris. Why, what are you doing? Why? You know why? Cannon? What? What are you- I'll deal with you folks in a minute. Oh, yes.
Saturday is my.
All right, very good. Sir, what's your name? Thank you, sir. You know, he picked a day, he doesn't see me. I say, everybody else picked a day, they see me. See, Laura Brown just came in being disrespectful, but I'm not gonna hold it against, I'm not gonna hold it against Commissioner Harris. All right. Well, that's a problem. All right, so.
So, Your Honor, I would respectfully request that these matters be set for.
All right. And all discovery is complete on these matters.
Best of our knowledge.
Would the people have their witnesses available the 22nd?
We'll do our best, Your Honor.
All right. Preliminary examination in these matters will be April 22nd, 2025, 9 a.m. That's before Judge Washington on both matters.
Thank you.
Thank you. Let's call the case of People versus Alfred Brown.
That's a lot of people.
Stephanie Cannon, listed on behalf of Mr. Brown, who's appearing to my right. Mr. Brown, please state your name for the record.
Thank you. This is Miss Cannon's first case today.
It is.
And she was absolutely, she was like, here.
Turn over a new leaf on it.
And like fall, that leaf's gonna blow over. But anyway, go ahead.
Just give me a few minutes. We're just gonna set this for a preliminary date.
Damn, okay. And is all discovery complete?
Yes, Your Honor, to my knowledge.
All right. And would the people have their witnesses available the 22nd?
We'll try, Your Honor.
All right, preliminary examination in person, April 22nd, 2025, 9 a.m. That is before Judge Fresh Hour.
And Your Honor, at this time, we will waive formal reading of the information statement.
Why would you do that?
What?
Wow, what are you doing?
Are you waiting?
I'm so sorry, Your Honor, I'm looking at.
No, it's okay. It's okay because you weren't able, no, you weren't able to get into the rhythm of everything. And you were back there and until his case got called, you were taking a nap apparently.
I'm sorry.
And so this happens when you wake up. You just kind of, no, you're good.
Your Honor, I am so sorry. My apologies for Mr. Brown. I'm simply setting the fee.
Mr. Brown, you're good. Don't worry about it. All right. It had nothing to do with you. All right. Bond will continue. All right. You take care. Cannon. Wow. Wow.
Thank you.
You're welcome, sir. Wow. I got confused. Court calls the case, People versus Ashley Hine.
And then on behalf of the people,
No. I got two on, right?
that's the public.
Thank you.
So if you respectfully requesting this matter be separate from the information.
Discovery is complete.
Sorry.
People have their witnesses available the 22nd.
We'll do our best, Your Honor.
Preliminary examination in person, April 22nd, 2025, 9 a.m. That's before Judge Washington. Bond will continue. Thank you. Court calls the case, People versus Christian Bird.
People. Stephanie Cannon, on behalf of Mr. Burke, who is here by Zoom.
You sure?
I am positive.
Okay, no. Mr. Bird, can you state your name, please, sir?
Yes, sir. Christian Bird, BYRD.
Thank you.
And Your Honor, we're setting this.
Discovery is complete.
Yes, it is.
People have their witnesses available the 22nd. Preliminary examination in person, April 22nd, 2025, 9 a.m. That is before Judge Fresh Hour.
Excuse me, Your Honor.
Yes, sir.
Is there any possibility it could be on Zoom or does it have to be in person?
It has to be in person, sir.
Okay. Alrighty.
All right, so you need to be here. All right,
Yes, Your Honor.
okay. Bond will continue. Thank you, sir.
Yes, Your Honor. You have a good day.
You do the same.
Yep.
Court calls the case People versus Danielle, is it Klimola?
Condition application earlier on behalf of Ms. Pomola, I've been here for the second one.
Okay.
Your Honor, today's date and time for a probable cause conference. We're asking for an adjournment. I did not give you the green sheets. However,
And why is that? It's okay. Any mistake you make, it pales in comparison to what Cannon did. So. You're welcome. So you guys can just mess up all of the points. The only thing that's gonna stick is what Cannon did.
That's a good part. Thank you, Judge. What we would be requesting, I have been in communication with people. We'd like to see if we can get Ms. Pomola into the drug court. So that's the purpose for this adjournment today. I do.
Into,
The 15th district Friday.
okay,
I have the.
referral and everything, all, okay, so I don't know what their timing is. It always changes. I put it out 3 weeks with that. Probable cause conference will be adjourned without objection, May 1st, 2025, 9 a.m.
May 1st?
Yes.
Thank you, Your Honor.
Bond will continue and I'll sign the green sheet once it gets here, like today. No, we'll wait. No. I guess we will. Court calls the case, People versus Antonio, is it Cornelius? I probably messed that up.
Sophia, are you gonna be at the people?
And Lord Yackey, Assistant Public Defender, with on behalf of Amelia Courtroom. We are asking for one more adjournment. Previously, we had referred this for restorative justice, and I don't believe that's not working out. So we're asking for one more adjournment before proceeding.
Before deciding what to do. All right.
Exactly, Your Honor.
Probable cause conference, April 24th, 2025,
Thank you.
9 a.m. Bond continued.
Thank you.
Thank you. Thank you, sir. Court calls the case, People versus Robert Mitchell.
That's a lot of people. So you're here with and I'll be back with Robert Mitchell, who's approaching.
Your name, sir?
Robert Mitchell.
Thank you.
We're seeking a brief adjournment for negotiations.
April 24th, 2025, 9 a.m. Bond continued. Thank you. Court calls the case, People versus Curtis Damon. This guy.
Because he needs the Spanish interpreter.
And Lord Yackey, Assistant Public Defender, with on behalf of Mr. Damon, who's approaching the podium. Could you state your name for the court?
All right.
And Your Honor, at this matter, we are seeking an adjournment. This is the first probable cause conference, Mr. Damon, and I are exploring treatment options for him. He is doing well, he is sober, but we believe that would be helpful for his case.
Probable cause conference without objection, May 1st, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, sir. Court calls case, People versus Megan Moses.
That's a lot of people.
Oh.
And Your Honor, my favorite day is Thursday and Tuesdays. On the off chance that I get to see you.
Hey, she wins. No. Your name, ma'am? Thank you. All right, what are we doing?
We are adjourning this matter with questions from the Honor. And further negotiations.
Gotcha. Probable cause conference, April 24th, 2025, 9 a.m. Bond continued.
Can I address Bob, Your Honor?
Yeah, go
You
ahead.
said I was winning, so.
Yeah, but that could change real fast. Go ahead.
Your Honor, Ms. Moses has no prior assault criminal history. She is not a flight risk. She doesn't have a stable home to live in Jackson with her mother. We also will provide her transportation to make further court proceedings. We are asking for a PR bond in this matter. We have no objection to any testing or any other conditions imposed by this court, including GPS tether.
Response.
Your Honor, the defendant currently has 2 holds out of Kent County. One for OWI, she was convicted up in 2023, or OWBI, excuse me, where I understand she still owes money on, and another for a child support warrant. The defendant also does have assault criminal history. She was not convicted, but she was charged last year with a domestic violence case that was ultimately dismissed. Furthermore, in this case, the defendant is alleged to have stolen packages and has sent, or is alleged to have sent, a letter admitting to and apologizing for the same to the victim in the case. There is an offer that has been extended to allow her to plead to a misdemeanor to days restitution up front. But I told defense counsel, given the fact that she has a warrant for not paying child support, she has a warrant for not paying her fines and costs on the OWI in Kent County, she has a residence in Jackson County and is here in Washtenaw County where she was previously living, stealing these packages. I am not convinced that she would come back to court, nor am I convinced that if she were to get out of custody, the victim would ever see the restitution in this matter if it's not paid up front. So I am requesting the court continue the bond as currently set, finding it to be appropriate.
But how's she gonna even have a shot at trying to get restitution if she's incarcerated?
And defense counsel told me this morning that her mother will be helping her make those arrangements and that she is going to be using her tax monies.
And Your Honor, if I may, you make a very valid point, which I would like to emphasize. My client does need to get out of jail to secure employment and to start paying off all those fines and costs that she needs to pay off. And federal tax day is coming up next week. So on April 15th, so if she's here and can't pay that off, that adds to it. And Ms. Moses did make clear to me that she does plan on securing employment and her mother will be taking her to the court proceedings moving forward.
Where would she reside if she were out in Jackson?
Jackson.
So all of her holds are financial holds,
Yes, ma'am.
right?
I do believe that the child support is a child support case related to.
Got it. I'm gonna modify the defendant's bond, grant the defendant's motion. I'm gonna modify it to a $10,000 personal recognizance bond. Defendant must be placed on a GPS location only tether prior to her release. Court calls the case People versus Quinard Sanders.
Andrew Childress, bring on back to people. You know, Mike Getty, he's just a fellow offender every time, but Mr. Sanders. Approaching to my right, Judge, state your name, Mr. Sanders.
Thank you.
Your Honor, I've had a chance to speak with Mr. Childress and Mr. Sanders. I do have a brief, I'm asking the court for a brief adjournment so I can check out a hold, and a C hold
That he might have.
yeah.
Probable cause conference will be during April 24th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the cases of the People versus Eric Fowler.
That's one thing.
We're ready. My client made it through the snow.
Yes. All right. I have before me a plea sheet that indicates that the defendant would be pleading, does not say, but I'm assuming guilty to attempt R&O.
Yes, sir.
Pleading guilty to attempt R&O upon a successful, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
Check my understanding. My client is ready to be sworn.
Yes, Your Honor.
All right. May I have it sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony about this to be the truth, the whole truth, and nothing but the truth, so help you God? State your name, your father.
That R doesn't stand for Rutgers, does it?
No, I don't think so. Riverdale, that's a Riverdale.
You're just making something up. aren't you? You just know I don't want it to be Rutgers. All right, sir, it is this court's understanding that you will be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that? You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Valvo in the 15th District Court. Do you understand that? All right. Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form today. Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will and because you believe that you're guilty of this offense? February 17, 2025, at the location of 1723 Green Road, City of Ann Arbor, Washtenaw County, State of Michigan. Did you come into contact with police officers from the Ann Arbor Police Department? What happened?
I called for a standby. I guess they called it.
A civil standby?
And I was unaware that I had a FOC. So when the officers got there, I didn't comply with the officer.
They wanted to take you into custody at the time. And what did you do to try to prevent that?
I kind of pushed them away. Just was unaware. I was upset over a family issue. I kind of not in the office. I know the officer was just doing their job, but I was unaware that I had a warrant, so it kind of caught me off guard. I was like, wait a minute, hold on.
Okay, I understand that, but when the officers were trying to arrest you, you pushed the officers away.
Well, no, not physically pushed away. I kind of just. I don't know how to explain it. I kind of just.
Yes, you may.
Yes.
They were performing their duties, is that correct? Yes, sir. And when they ordered you to come with them, you did not come to them. That's their word. Is that correct?
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Keep us satisfied.
Absolutely, certainly.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
29th at 9 a.m.
April 29, 2025, 9 a.m. before Judge Valvo.
Yes, it does. Put it in there.
So yeah, I guess I do.
It's a waiver. You really.
Yes, okay. Thank you. Thank you, sir. Court does call the case of the people versus Romeo Smith. Does call the case people versus Dijon Gray.
Like, yeah, he's just a defender on the end, where he's approaching the right, Your Honor.
Your name, sir? You're requesting an adjournment regarding video.
That's correct.
Probable cause conference will be adjourned May 1st, 2025, 9 a.m. Bound continue.
Thank you.
Thank you. You're upset, sir. Court does call the case of the people versus Frederick Sullivan.
Stephanie Cannon, on behalf of Mr. Sullivan, who is appearing to my right.
Mr. Sullivan, when you are present, would you please state your name?
President Sullivan.
Thank you.
Your time is waiting up.
He's doing a waiver. All right. Sir, is that correct?
Yes, sir.
You're waiving your right to a preliminary examination? You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that that hearing will not happen and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2. And Ms. Cannon, you have been looking all day to say this, so go ahead.
People waiting for reading information and that's the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 21st at 1:30 p.m. to Judge Hamud.
April 21st, 2025, 1:30 before Judge Hamud. Before Judge Hamud. Bond will continue. Court calls the case People versus Elijah Stewart. Now, you know what? You know who it is, don't you? Yeah.
Stephanie Cannon, present, Your Honor.
Elijah Stewart.
Your Honor, my client is.
Was it good? No, go ahead. My bad.
My client is asking for a 2-week adjournment for investigation.
All right. Any objection from the people?
No objection, Your Honor. I would like to address one briefly.
Okay. Probable cause conference will be adjourned to 24th as to bond.
Your Honor, my understanding is that the defendant is currently on the GPS tether. It's just a general location GPS tether. We have requested that there be a hot zone added at the time of arraignment. But I would like to remove that request for a hot zone at 2500 Holmes Road where this is alleged to
Now, we don't argue against any modification of bond at the time. Since that order has been put in place, we received no information that my client has done anything wrong. Comes to court, is doing everything he's supposed to be doing, there's no need to modify the bond at this time. I imagine if he is now not getting in what he's supposed to be giving in, or if some information has happened. But they're just saying we didn't win at the magistrate level, so now we're asking you. So I would just say.
Well, you guys do the same thing.
Yeah, we do, Your Honor.
All right.
You go, no.
Wow.
You know.
Not well. Sometimes you gotta have more reasonable requests like Miss Willing brings.
Yeah.
All right. That's the location of the alleged arson.
and where the victim,
Pardon?
where the victim.
Does the defendant have any reason to be in that area at all?
Work nearby, but not right there. That's not inside the trailer park.
When you say nearby, what do you mean?
Showing them here, it's over on Michigan Ave. My place is on Holmes Road.
Your Honor, my client is not going to that address. He has not been going to that address. He will not go to that address. I don't believe the GPS has pinged it in that general direction or in over there. Trust me when I tell you, my client is very done with that particular individual. He wants no contact.
I'm gonna add a hot zone will be added to the GPS tether. We'll do location tracking, but there'll be an exclusion zone of 2500 Holmes Road.
just trying to make it so that you.
Pardon?
He just wants to make sure that his job is not that far from there. He just wants to make sure he's right.
How far is it from there?
Well, Holmes Road and Michigan Ave, they crisscross. There's a street in between them called Wired. It's not that far, but it's not in the neighborhood.
Right.
It's walking distance, but it's not. I'm not ever.
All right, when you go over, I'm gonna add that condition, you go over to community corrections, you make sure to let them know where you're working and give that, I mean. But if it does go off, we will figure that out. Okay. All right. In all other respects, Bond will continue, we'll prepare a new order to send over to community correction.
Thank you.
Which we already have. Court does call the cases of the people versus Matthew Fitzgerald, 2 cases.
Thank you, for people.
And good morning, Your Honor. Robert Allen, on behalf of Fitzgerald, in case 5072. We need.
Okay, where's my second ruler? Oh, no, saunter up. We'll wait.
Assistant Public Defender, Tamika Carey, on behalf of Mr. Fitzgerald.
Your Honor, I want to start by thanking you for passing this case earlier, allowing us this time.
All right. Have you seen the community corrections violation report?
Yes, we have, Your Honor.
What are you doing on this today?
Your Honor, as far as my case itself, I'm asking for an adjournment. I was disappointed yesterday, and there'll be time to obtain discovery. If you'd like us to address the violation, we can go right to that.
Go ahead.
So, Your Honor, the test on April 2nd was my client's first test. He also has a case out of Livonia that he actually tested for yesterday and tested clean. He says that he will test clean today.
Do you have those results?
We do not, Your Honor. I didn't have an opportunity to call Livonia. It's on-site substance abuse testing here in Washtenaw County. We can absolutely reach out to them. He states that he did not sign a release of information, but it seems like he was confused, Your Honor, because of his testing obligations in the Livonia matter. He didn't realize that he would have to be simultaneously testing. I told him that he could sign a release.
How long has he been testing in Livonia?
That was my second week.
What was your second week?
Yesterday. Yes, second time.
What do you have as his appointment, Jane? Well, I have his arraignment date is March 31st. I have a test on April 2nd with a report on April 9th that he's positive. He was instructed at the time of arraignment he's not supposed to be using drugs. He's positive for fentanyl, cocaine, opiates, and amphetamines.
Your Honor,
Also, as I'm to understand that at the time he tests positive for these, he's also not supposed to be using narcotics from his order out of Livonia. So you'll be in violation in that case also. Go ahead, you wanted to say, Mr. Allen.
Well, Your Honor, I think with his arraignment on the 31st, I do know I'm not a scientist, but we know that sometimes it takes some time for drugs to get through the human body and out of the system. And as I said.
Is he gonna tell me that that he did not use after the 31st?
He says he did not use after the 31st. Again, the positive test was on the 2nd.
When did he test in Livonia before that?
I cannot tell you the exact date, but it was around the same time. It's the second.
Your Honor, if it helps to establish the timeline, Mr. Fitzgerald would have been arraigned on his OWI out of Livonia on February 4th of 2025. He then, his next appearance in that case was when he entered the plea on April 1st. I'm assuming that he was transferred there after being arrested on this matter, which obviously occurred the day or two prior to that. And controlled substance possession is obviously one of the charges here.
So what makes me think if he was in violation of Livonia's orders that he's not going to be in violation of mine? Because he is in violation of mine. This one.
Your Honor, all I can ask is that you give him a chance to show you that he can follow your rule.
And then I'd like to add also that, if we can, I don't know what the conditions, for his Livonia case would be, especially now that he has entered a plea. But I know that here, obviously, we've got outpatient treatment, we've got CCOP, we've got some inpatient options. Clearly, substance abuse is an issue at this point. He says that he has been trying his best. He reports that he would be clean today. We don't have the results from the other test yesterday, but hopefully those are also negative for any substances, Judge. So we ask if he could at least have the opportunity to get an evaluation or assessment to see if we can get him going into that treatment program.
Anything else you want to say?
Well, Your Honor, just that you give him a chance. Like I said, he can, like co-counsel has said.
Well, let's do this. You can get a release from him. I want those Livonia results because something's not quite adding up. He's and it's not like it's one drug. He's got a whole cocktail in him when he comes here to testify or comes here to test. So I'll adjourn his probable cause conference to next week, the 17th, 2025 at 9 a.m. And I'll just say this, I also am not believing, given the basically shelf life of some of the drugs in his system, that he didn't use after I am not convinced that he didn't use after he was arraigned. So at this time, defendant's bond is revoked and you guys can get a release of information from him and make a determination as to getting those test results to me, and I'll take another look at it.